Rachel. Welcome to Privacy Chats.
So this is a forum for Rachel and I to talk about issues that interest us about privacy. We hope that you find them interesting also, and we're glad that you've joined us.
Yeah, and I'll quickly mention that our last episode was our first episode, and we presented the history of privacy through a chronological lens. So we looked at some of the earliest mentions of privacy as a universal concept, and we did so through sharing stories from the mid-20th century up to, going back all the way to the earliest privacy case laws. We followed some issues coming out of more modern technological developments. We touched on the FTC's Fair Information Practice Principles, and we even took mention to the OECD guidelines and sector-specific laws in the U.S. So I certainly learned a lot through the preparation of that episode, and if you haven't checked it out, go ahead and do so. It'll be great. It'll be a great setup for this episode, I think.
Yeah, it was fun doing that episode. I enjoyed it, and I think we both went down a lot of rabbit holes with our research for it. But it was interesting. So just before we get into this episode, to offer a disclaimer that both Rachel and I are experienced and certified privacy professionals. We're both working in the industry. But we just wanted to be clear that the stuff that we're going to talk about is just information that we find in our own research using the same Google that everyone else has. We're not going to be revealing any trade secrets, and we're both employed, but we just wanted to be clear that we're not going to be talking about, we're not representing the thoughts or opinions or policies or anything of our employers or anyone else. It's just Rachel and I talking about stuff in privacy that we think are interesting.
Great setup on that disclaimer, John. I'll add that, this episode 2 is, aimed to cover a lot of content that we realized we couldn't cover even in the first episode. Throughout that history of privacy episode, we talked about a lot of developments in the U.S. related to case law, but we only scratched the surface of a lot of privacy's conceptual origins, which tend to stem from principles and frameworks that have arisen out of Europe in the 20th century. So John, what do you have to say? I know you have a little bit of a connection with Europe, to put it lightly.
I do. So while I was born in the United States, I was just a wee lad when my family moved to Ireland. I think I was about 5 years old, and I grew up in Ireland. I went all through school there. And I graduated high school and stayed there for one more year. Actually worked as a bartender in Dublin for that year before moving back to the United States, and then I got into military service here. But a lot of the stuff that we're going to talk about here, or some of it, are things that I remember from growing up in the time frame that I did. And if you haven't noticed it, I'm a little bit older than Rachel, so my recollection of things goes back a little bit farther than hers. But I do have a close connection with Europe. I still have a lot of family and friends there. What about you, Rachel? Do you have any connection with Europe?
So not as directly, of course. I've lived here in the U.S. my whole life. I did call my mom to double check when the most, recent, generational connection was with Europe, because I know I have a lot of ancestry in there and it's all over the place. But what I did find out was that very early on in the 1900s, my mother's mom, my Nana, she grew up in a very small town in Pennsylvania from Lithuanian immigrants who came here right around the time of World War I, which I thought was interesting because I kind of figured for a while it was earlier than that, but it was more recent than I realized, which is cool. And, I used to ask my Nana a whole bunch of questions about her family and growing up in a small town and, having grown up in also a community where a lot of immigrants were from. It was very heavy Italian and Polish immigrants in there. So she kind of had a new, fresh set of eyes as a child, at least, that I remember hearing a lot of stories about with the U.S. But yeah, I guess, how does this tie into, U.S. and EU history? What do you got for us, John?
Well, I think it's, we always see the United States as a melting pot, and, there's certainly people from all over the world here, and it's great that our country is made up of people from all over the world. But there are a lot of people from Europe. That's clear to see just looking around. So I think that it's important to point out that connection between Europe and the United States, and even going back to, the people said for a long time that the United States was discovered by Christopher Columbus. So that's a connection going back to 1492 when Christopher Columbus came from, was it Spain or Italy, Genoa in Spain? I'm going to say Spain.
Yep.
Okay. It turns out that Christopher Columbus really just discovered people who were already here, and sadly he enslaved them. So we're really not supposed to celebrate the accomplishments of Christopher Columbus anymore because of that. But the connection goes back a long time, and I think go forward from that a couple hundred years to your reference. Next, back to you, Rachel.
Yeah. So I'll cover quickly the additional bridge and the reason why I think a lot of our concepts, even though we run our country a little differently than a big continent like like Europe, is just due to the fact that like our earliest, at least colonial settlers, were from Europe themselves. Back in history, I recall that Mayflower Compact being that agreement that was signed between the English pilgrims that came here for the purpose of religious freedom. At the time they were experiencing the Protestant Reformation, and they felt that their principles and how they wanted to worship was not aligned with the Church of England, and so they came here to seek that freedom of expression in that way. And that's really our main connection. Of course, there's plenty of history after that reinstates that and brings in other European settlers, and for different reasons, but that was the catalyst for at least the earliest Americas.
Yeah. So the getting into the differences between the United States and Europe, and really to draw the parallels with our last episode and talking about the overall history of privacy, which in that episode we were really more focused on the U.S. But I think that the key difference is in the structure, and I'll start with the creation of the United States as a country in 1776 with our independence. So our country has always existed as a collection of independent states operating together. Hi to your cat there.
Yeah, he's listening.
So a collection of what started as 13 states, and that number grew, but working together to have one country together, which is really different than the way Europe operated. So Europe is a bunch of different countries, and that number of countries has changed over time. And I'm assuming that's because they have merged and split up for whatever reasons. But throughout its history, and European history goes back far before the United States ever existed. But essentially, the countries in Europe existed as independent entities throughout most of its history. And then I'll bring up to some pivotal things that happened in the earlier in the 1900s that kind of brought about the necessity for some change. And I'll turn it over to you to talk about some of those.
Yes. So, as listeners might imagine, that pivotal event was World War I and World War II. I wanted to, focus most of my research on how things and concepts and groups coming out of World War II came about, but I can't do that without mentioning World War I as the major tie-in. The idea was that, World War I, after that was finally cooled down and settled, it would have been the end of all world wars. It was marked by the Treaty of Versailles in 1919, which ended up imposing pretty harsh terms on, Germany too, as we were about to experience the rise of Adolf Hitler and the Nazi Party during that time, where there was a huge focus for Germany on nationalism, militarism, and expansionism. So kind of thinking about what you were saying with, they operated independently up until one point. There was this vision that, Germany could take over the world and take over Europe in the process. So a lot of that early World War II setting was characterized by the aggressive expansion, and then the violation of pre-existing international agreements. This spurred more military conflict. As other nations responded to this, we ended up getting allies and having two sides formed with this. And at least what I recognize as the end of World War II would have been that attack on Pearl Harbor, which we now have a highly acclaimed movie out for. I have yet to see, but looking forward to it. But yeah, the atomic bomb drop on Hiroshima and Nagasaki was considerably the end of World War II, as tragic as it was. But it did bring about new ideas for new agreements to say, hey, like, we know this was an atrocity, to put it lightly, this 2 major world wars back to back. Like, how do we band together and make sure this doesn't happen again?
Yeah, and I think that was the key focus is what needs to happen, or what needed to happen in I guess in Europe, but really across the world, to prevent anything like that from ever happening again, both from the countries invading each other in Europe, but also the terrible atrocities that happened against populations of humans during World War II. So that kind of theme of what is it that we have to do to make sure that nothing like this can happen again. And I stumbled across, in researching that, I found a quote from Winston Churchill from 1946. And he was talking about remedies, and said that a remedy which, as if by a miracle, would transform the whole scene and in a few years make all Europe as free and happy as Switzerland is today. And then said, we must build a kind of United States of Europe. So it was kind of interesting that, this Europe, having existed for thousands of years, and, one of the key leaders in Europe during World War II and post-World War II, was looking at what was a new experiment in the United States as the template that they should follow. And I think that his idea was that if Europe could form that partnership, then it would prevent any individual country like Germany from rising up and trying to take over all of its neighbors as Germany did. I think that was pivotal. And I saw in your notes something about Eleanor Roosevelt, so we'll turn it over to you. But, noting that sadly her husband, Franklin Delano Roosevelt, who was a president for 16 years.
The longest term? Yeah, ever.
The longest term, right. The only president to serve 3 terms, or 4, was it? He was elected to a 4th term. Anyway,
I thought it was 4, but there had to be a caveat somewhere.
Yes, but anyway, he didn't survive the war. He died before the war ended. But Eleanor was still around, and I'll turn it over to you to talk about how she influenced things after the war.
So yeah, Eleanor Roosevelt, what a woman. She clearly took the baton from her late husband, and in doing so, got herself involved in the UN General Assembly following World War II. What she ended up being a part of was actually the drafting of the Universal Declaration of Human Rights, which I'll just call the Human Rights Declaration moving forward, since it is a bit of a mouthful, that all 4 words instead of 3. But this declaration contained 30 articles that detailed just individual basic human rights, fundamental freedoms that people across the world should have. They're reaffirming the, universal right to privacy is a very relevant one, stating that no one shall be, subjected to arbitrary interference with their privacy, their home, family, or correspondences. Other rights included in there were, of course, the right to own property, the right to marriage, the right to a fair trial, all very common concepts to us today. What I found interesting was that on top of the right to privacy, there was also a mention of a freedom of expression. Now there's always a balance to strike between the right to privacy and freedom of expression, which is actually called out in this doctrine as well. So I found it interesting that this idea that there's kind of proportionality to balance these two things is, we need to protect everyone's absolute rights and necessity, but there might be a justification to, balance privacy for the sake of protecting, humans and all their other unalienable rights listed in this doctrine. So yeah, that was my tie into at least Eleanor Roosevelt. But the most powerful part of the Declaration, I think, from my perspective, is that there's an agreement between European states, right? There's said to be also a kind of a binding contract, and that breaches of these fundamental rights would warrant enforcement, in change in local legislation, if the rest of the coalition in the UN kind of found that this wasn't honored. But this right to privacy and the rest of the fundamental rights too would ultimately set the stage for a lot of language we see in guidelines and data protection laws following the next 75 years.
Yeah, so the Universal Declaration of Human Rights of the United Nations, my understanding was that was intended to kind of influence human rights practices around the entire world. But bringing it back to Europe, what we're talking about today, so following that Universal Declaration of Human Rights in Europe, which really suffered the brunt of what happened in World War II, they created the Council of Europe was created specifically with a goal of addressing human rights, and that's a council that still exists today and is still focused on promoting and protecting human rights, not just in Europe but across the world. So following the Universal Declaration of Human Rights, it created the European Convention on Human Rights and Fundamental Freedoms. And it has, I forget how many articles, but the ones that are most pertinent, and I thought it was pertinent to point out that Article 2 focuses on the right to life, which, for a lot of Europeans during World War II, that was the right that was taken from them. They were simply murdered by the Nazis. Then it goes through a bunch of other rights similar to the ones that you talked about. But in getting up into Article 8, 9, and 10, really specifically focus on privacy. Article 8 specifically says that everyone has a right I need my glasses to read. It's all right. To respect for his private and family life, his home, and his correspondence. Try not to wear my glasses. There's too much of a reflection.
Yeah.
And then Articles 9 and 10 have similar rights that really are kind of a tribute to privacy. So I like that, as you said, that what happened in these conventions, serve as a foundation for a lot of privacy laws and stuff that I think we're going to talk about next. But that it's the foundation of it is embedded in what is fundamentally about human dignity and fundamental rights that humans have, which is really cool, I think.
Yeah, and it sounds like the Council of Europe really picked up what the UN basically started with their declaration. Sure. and took a lot of the concepts verbatim, basically. But what I also found in my research is kind of interesting. And throughout the rest of this chat, I had to revisit and kind of reframe what would have, especially under the context of privacy, would have been relevant at the time, because we're talking about this right to privacy as and I think we're used to in the modern state a lot of the guidelines and laws being very reactive to problems we've seen and experienced related to technology. But early in the 20th century and up to the 1950s, it's not like computers were universal and ubiquitous like they are today. They were
Sure.
very early and preliminary. They were really the closest computer that was grown in mass was the tabulating machine, which we know they don't actually store or share information like computers do today. Sure. And certainly not digitally. They were only designed to really summarize information on physical punch cards, and this was helpful for things like census counting and accounting functions and calculations. Some of the the more advanced tabulating machines actually ended up being developed by a company that would later be known as IBM. So I found that being a funny origin that I hadn't realized either. But these very early machines, they switched to plug boards eventually, but even in the 1920s, it didn't mean that they were super fast or had incredible speed of calculation or the functions that it had to be written to do. There wasn't any configuration, there wasn't any information exchange. It was very much just do addition, subtraction, multiplication, and division, and it was slightly faster than doing it by hand, right? And right. Again, for specific purposes, that's helpful if you have a lot of figures, but they're not computers like we know today. So I think it's interesting that with all of these talks about privacy, it has nothing to do with information exchange over the internet, over even telephone wires that much at the time. It could have been a possibility, but we hadn't quite got there yet. So we're not playing catch up at this point. This is just what the largest powers of the world will recognize as just basic rights in the ideal freedoms of individuals.
Yeah. And it's kind of a nod to one of the concepts that we talked about in our first episode, that the evolution of privacy laws seemed to go hand in hand with the evolution of technologies at the time. So bringing it back to Europe and the laws, like, how did things evolve there in a way that led to the European Union being able to exist as it does today? And we'll get into GDPR stuff later. But it's in my research, I found that this Council of Europe that was initially put together, that Convention of Human Rights and Fundamental Freedoms, followed up from the success of that and created in 1951, it created the European Coal and Steel Community, which at that time was just a collection, like 6 countries agreed to common management of coal and steel resources. So it was a kind of an economic thing. And that was successful, so successful enough that in 1957, there was a Treaty of Rome that expanded on the success of this coal and steel industry thing to broaden and that economic sectors, beyond coal and steel, and added other countries. And that then became the European Economic Community, or the EEC, which is something that I remember from growing up in Ireland during the 1980s. Which led to, in 1993, the Maastricht Treaty, in 2009 the Treaty of Lisbon. But basically, what started off as independent countries, through these small treaties and agreements and the passage of time and people getting used to the fact that, hey, when we work together as a common community, things are better for us economically, and that European Coal and Steel Community eventually grew into what is now the European Union. And I think it's necessary to talk about that, because without the European Union existing as it does today, they wouldn't have the power and the oomph to do something like GDPR, again, that we'll get into and talk about. So yeah, I'll hand it back to you, Rachel.
Yeah, and that's a wild origin story, because I mean, especially coming from my very, very through and through formal American education, I think of the EU as the EU. It's always been that coalition, and
yeah,
I don't,
sure.
I don't question, the evolution over time with it not really starting to be that, but ending up as being the influential group that it is today. Especially going back all the way to the 50s, where those large economic powerhouses were the coal and steel community. So it makes sense, as the evolution of anything great does. But I will mention, because you talked about the EEC, according to my research, was the original OECD, right? And it sounds like that it was also built to administer the Marshall Plan. But if I can take it and go into the how it relates to privacy and what the impact that the OECD made as of late.
So yeah, I'll just stop you there for a little bit. So the OECD, because I found that in my own research, started out as the OEEC, but I think they're two different. The OEEC was not the European Economic Community.
Oh, interesting.
Yeah, I don't remember exactly what the OEEC stood for. I should have added it to my notes, because I have it referenced here in my notes. But yeah, like you said, the OEEC was developed after the war, so 1948. To administer the Marshall Plan, which was kind of economic recovery for Europe and aid coming from the United States and Canada to help, because Europe was really devastated because there was so much war that happened there. But yeah, I didn't get that connection between the EEC and the OEEC, which really are two different things. But the OECD, which we talk about as a framework, which I think you're going to talk more about now, did evolve from an organization called the OEEC. So a lot of acronyms there, but I think you were going to talk about some of the frameworks from OECD.
Yes, the origins of the OECD you clearly covered here. But it did give this platform for governments to collaborate and share information, and develop solutions for a lot of the global challenges that I think they were shared as globalization caught up. And I mentioned the OECD guidelines. because the guidelines, and I'll just coin it as that, they're actually the guidelines for the protection of privacy and transborder flow of personal data. These were developed in 1980 by the OECD, and it's really just laid out the basic rules that now govern and were meant to govern cross-border data flows. So country A and country B wants to exchange information that might have something of personal nature to their citizens or to individuals. The idea was to create a framework to still allow this to happen, because it's likely that was meant for economic development and furthering the strength of economies and through transactions in business. But we did recognize, of course, here through the development of these guidelines that we still need to protect individuals' privacy, but not stifling innovation in the process. There needed to be a balanced approach, but we didn't have a foundation for that. What does that mean? So the principles that the OECD set out, and I'll just use their principles without going into detail with each of them right now. They were collection limitation, which listeners might actually find a lot of these very familiar. They're used today in a lot of different settings. We have collection limitation, data quality, purpose specification, use limitation, security safeguards, openness, accountability, and individual participation. They were, again, and I'll repeat myself again, they were put in place to, reassure that if you abide by these guidelines and you consider these in when you transfer information, you shouldn't create unnecessary obstacles to information exchange between, especially the member countries that are volunteering for these to adhere to these guidelines. Under all this, I've also read in these guidelines that there's a intention for all transfers of personal data to be secure and uninterrupted, and of course between member countries, there's no way to impose additional requirements on top of this, so long as the country that you're sharing or receiving information with also has the standard of practice within their data management. So adequacy of transfers, it's a common concept that was all the way rooted into the OECD guidelines.
We talked, I think, last time about the fact that the OECD guidelines were really foundational in the privacy industry. But the limitation of them is their guidelines are really suggestions. So the next step of that was that, at least in Europe, was that the Council of Europe, which had already been successful focusing on human rights, put together in 1981 what became known as Convention 108. Its full title is the Convention for the Protection of Individuals with Regard to Automatic Processing of Personal Data. So again, they're focusing on their core mission as an organization of protecting human rights. So this Convention 108 really took the guidelines and formed them into something that had more meat to it. Now, the Council of Europe didn't have the authority to tell the countries across Europe, you have to do this thing. But it really invited the countries across Europe to come and adopt these practices. So countries were invited to come and sign this convention. And by signing it, they were agreeing to go back to their own countries and enact regulations and legislation in their own countries that codified these guidelines into law in their own member countries. So that convention was open to be signed by countries in 1981. Was the first legally binding international instrument in the data protection field. And what was interesting to me is that the objectives of the convention the first one was the free flow of data, which I think is significant to point out, because a lot of people think that the privacy regulation, privacy laws are about restricting the free flow of information. Like if we can protect people's privacy if we stop this data from flowing places. And that's really not the intent. We want there to be a free flow of data, but adding on to that, the second objective of the convention is respect for human dignity. So let's accomplish both of those things, the free flow of data, so that, not just commerce can exist, but, I think it's beneficial to all of us for data to flow, because then a lot of the things that we enjoy and benefit from can exist. while respecting human dignity, which is what privacy is about. So over the course of time, 55 different parties signed this. 20, let me get the numbers right. 45 of the members were European countries, and 10 were non-European states. So they weren't limited to just Europe, even though this is the organization is the Council of Europe. They're inviting really any country from around the world to come and adopt these practices. Noting that things change, Convention 108 was updated in 2018 with a bunch of new provisions. Some of it around the automated processing of data, which clearly can be done a lot better and easier today than it could decades ago. New stuff about the transborder flow of data, and I think we'll talk more about that. Additional rights for data subjects, and that's open for countries to come and sign it today. And it serves as a kind of a foundational privacy structure, I guess, in the world, across a lot of countries throughout the world.
Yeah. And I similar to what I thought of when we were researching some of the catalysts of these groups and these guidelines are contextualizing for technology at the time. We're talking about the more recent Council of Europe and Convention 108 comes around in about the 80s, which I won't know firsthand, but I know that personal computers did actually start to become more of a household thing. Going back to talking about conversations with my Nana and my grandmother when I was really young, I remember asking her when I was like 6 or 7 years old, like, did you have, what does your computers look like? Just assuming she'd have them around, right? And she's like, man, I don't think I saw a single computer until like the late 80s. And as soon as I could get my hands on one in the 90s, she's like, I wasn't, high tech at all, but it was really a purchase. And then I started using it. But then she explained how they were really, these giant mainframe systems that maybe were in libraries, but mostly in a research setting. But finally, up and through the 1980s, which brought me back to my research here, it was the first time personal computers were becoming accessible, really. We had, early models like IBM's PC and the first Apple Macintoshes. So they're starting to be influential in the small business space, and just more and more people are becoming familiar with technology and what it can do, and actually getting involved in developing its capabilities themselves. Recall earlier when I was talking about like the punch cards and the switches, like those were not machines that you had in your home, and you, especially for that reason, didn't know how to use unless you were really deep in scientific advancements and in development for very large and organizations with a lot of money to spend on that. So it's not like you could just go and get your hands dirty with the computer technology at the time. You had to wait, and 80s were the time of the wait to end. So we got graphical interfaces. You have the computer mouse. Well, gosh, you can manipulate things on a screen. That's crazy. You can start storing a lot more data than you could, and it's not on paper. They're now on floppy disk and hard drives. We have modems that allow people to communicate over the internet, and then of course the rise of productivity applications, which to me strikes that relevance for the personal data transfers and security of it. And that combined with the next 30 years of like storage development, it's no question that a lot of the conversation around privacy and revisiting these, quote unquote, older decades ago principles related to the right to privacy start to come up again. You have a whole generation of users that didn't behave or think about solutions to modern problems like they did with the tools they had at hand now. So that's a bit about what I wanted to add with kind of contextualizing some of the more recent developments like Convention 108, and you mentioned the protection of individuals with regard to automatic processing of personal data. That automatic processing probably wouldn't have been a term we needed to use back in the 40s when we were talking about the UN Convention, but now with the prevalence of information flow and the speed that you can do that on a less manual basis, it's very, very prevalent for protecting users, as there's more vectors to kind of perhaps exploit users' privacy for nefarious reasons across different government entities.
Agreed, and it's significant to you got to give credit to the people who were there, dealing with these problems at the time. Last week we talked about FIPS, which were developed in the early 1970s, which was the first time that they recognized that this was possible to like automatically process data. So going into the 1990s, then one of the key aspects of data protection was the 1995 Data Protection Directive.
Talking about the 1995 Data Protection Directive. This is also known as the Directive 95/46/EC, which I wish I knew what any of that meant, but I didn't get that deep into the research on that in this episode. But it is an EU directive that establishes a comprehensive framework for the protection of personal data within EU member states, not unlike anything we've heard so far. But the aim of this directive was quite different from what we've discussed now, which was the harmonization of data protection laws across the EU, and also including certain rights and protections that maybe weren't included in other frameworks and guidelines, and certainly weren't enforceable in the same way as the directive is. Some of the key features of the Data Protection Directive included additional data protection principles, some requiring and emphasizing consent as a prerequisite for processing personal data, granted data subject rights, such as accessing and rectifying. There's also protections for sensitive data, cross-border data transfers, and piling on top of what had already existed, but actually putting it into the context of something that is more legally binding than other things like guidelines that we've talked about. It is, of course, a foundational framework in the EU, but as technology advanced as it continues to do, and especially thinking about what was available and prevalent in 1995, even though not that long ago, compared to how we use technology today, there's still a very wide delta. So what was nice about this directive is that it started, specifying that we needed a harmonization, but as technology continued to evolve, it didn't quite, I wouldn't say go away, it didn't attack everything. So I'll tease out that was the kind of predecessor to the GDPR, highlighting a bit more specifically what needed to be laid out in a more comprehensive and stringent way as far as data protection rules, especially, of course, it being a regulation over a directive.
Yeah, and one of the pieces that you said that were significant in the 1995 Data Protection Directive was about the trans-border flow of data. So that's a really significant piece because, obviously we're a country that's outside of Europe. So any data that flows between Europe and the United States falls under that. And one of the provisions, or an outcome of the Data Protection Directive was something that was called Working Party 29, which was, I guess a group of people that were put together to figure out how to operationalize some of these the provisions in the directive. And one of them was dealing with this whole trans-border flow of data. So in 2000, there was a framework developed and put into place called the Safe Harbor Framework, which really kind of ensured that the practices for data protection in the United States were similar, or at least adequate, to what was expected in Europe. Because without that, if they're protecting data in Europe, they're allowing that data to flow to a country that's not going to protect it when it gets there, it really doesn't, it's no protection at all. So the expectation is that the countries that they're going to allow data to flow to have adequate protections in them. So the Safe Harbor Framework essentially established that adequate protection existed in the United States. I'm going to go chronologically through some of these things. So the next thing chronologically that I wanted to point out is in 2008, there was an update to the FISA law, which is about the data transferring in and out of the United States, and particularly with foreign investigation of foreign activities and stuff like that. So FISA 702 was a section that was a key part of this in really some of the problems that we're having today with data transfer between the United States and Europe. So Section 702 is a key provision of the FISA Amendments Act of 2008 that permits the government of the United States to conduct targeted surveillance of foreign persons located outside the United States with the compelled assistance of electronic communication service providers to acquire foreign intelligence information. So essentially what that's saying is that the United States as a nation can spy on people outside of the United States because we want to do that for, protecting our own interests. And, we could reference 9/11, for example, and, reasons why we want to spy on other people outside of the country. But interestingly, like when you look at laws in the United States, like even the Constitution itself, legal scholars will recognize that the Constitution in the United States is written to protect American citizens, and that those protections in the Constitution don't extend to people who are not Americans. And it certainly doesn't extend to people who are not in America. And that's really a problem for people in Europe because they recognize that the laws in the United States aren't there to protect them, which is kind of unfortunate because if you read some of these laws that we've been talking about, it's clear that the intent of those laws is to protect humans, and it doesn't just focus on the nationality of those humans. In fact, in some cases, it really compels the protection of people, even though they're from another country, that if they're here within the boundary of our country or within Europe, that they should be protected also. Chronologically moving forward, a lot of us remember Edward Snowden, who was famous for revealing a lot of internal secrets from some of the intelligence organizations in the United States. And I didn't read a lot of the stuff then, but the essence that I got out of it was that he was kind of revealing the extent to which our intelligence agencies really were spying on people. And that, was a problem for people in Europe who don't want to be spied on and want their data to be protected. So a lot of, I think a lot of the reason for the next thing was because of Edward Snowden. But in 2015, the Safe Harbor framework was invalidated by the Court of Justice of the European Union. And they said, the protections in the United States aren't adequate anymore. That's often referred to as the Schrems I decision, after Max Schrems, who was an Austrian activist, although I think he was a student when he first started working on this, who essentially brought a lawsuit saying that the rights and privileges for him as a European weren't being protected here. So what there needs to be a framework so that data can flow between Europe and the United States, because we are fairly tight partners. So that was replaced with the Privacy Shield in 2016, which was overturned, unfortunately, in 2020, again by Max Schrems and some of the lawsuits that he brought, which is often called the Schrems II decision now. In October 2022, so less than a year ago, the European Union US Data Transfer Framework was put in place. And the key differences with that framework is that it puts together kind of a mechanism for someone in the European Union to question if US intelligence agencies have their personal data, and there's a provision for them to ask for that data to be I guess deleted, the right to be forgotten, for example. But it's I think to be determined if that's going to stand. I've listened to Max Schrems on some podcasts, and he's kind of said that the European Union US Data Transfer Framework is really the same as the last two things that have already been overturned. So clearly he's going to fight against that. So I'm not sure where that's going to go, but this whole issue of the cross-border flow of data between the US and the European Union is really a hot topic. But it's something that we have to solve because, we are close partners with a lot of countries in Europe, and we need data to flow between the two entities. So hopefully we can solve that. So I all I can say is stay tuned, and we'll see what happens. But in the midst of all of those things that I talked about, the place that we started going to was GDPR, and I know we're not going to be able to talk about the whole thing, but you want to tease out some stuff that we might be able to talk about GDPR, Rachel?
Yeah, and I'll kind of bridge it with some of the story that you just shared here, with all of the the various versions of Schrem's acts, this balance between information sharing and safeguarding individuals regardless of their association or their location. It goes all the way back to 1948. When we were talking at the beginning of the episode of the Universal Declaration of Human Rights, like, yes, we have a right to privacy, but that has to be balanced with other aspects of again, freedom of expression, and then the proportionality of keeping individuals safe and out of harm. There seems to be that conflict where we all agreed and we can opt into such an agreement or a coalition, but it seems like there's breakdown maybe spurred by the modern advancements in technology and changes of opinion based on more modern events, like you were mentioning. The U.S. had a very strong military position and always has, but it was exacerbated by events like 9/11 and some of the world global affairs happening in the late 90s. It can't we can't bulldoze over some of the principles we all collectively agreed to at the beginning of the century there.
Sure. If I could jump in on that point, like it's interesting that like more recently in the United States, people have questioned TikTok, for example. So TikTok is owned by ByteDance, which is a Chinese company, and have concerns about their personal data in TikTok being transferred into China, and worried about the Chinese national data protection practices within that country. So, and some people are saying, well, we need to make sure that all of our TikTok data for U.S. citizens stays within our borders. But it's interesting that we don't want our data to go to China, but we have concerns when Europeans are saying they have concerns about their data coming to the United States. So, it's you can't object to one on one side and not the other. Like
it's got to go both ways. if you're feared that you're being spied on, then right, it can happen to anyone, and we're a globalized ecosystem. There's no world where we're just performing trade and business within our own country, let alone an entire group of countries, a whole continent. So totally agree. It's going to be a sticky situation. It makes me wonder about outcomes like Schrem's, like what was it, 3? What was after 2? They call it Schrem's 3?
Well, we'll see. I mean, I guess if they turn over the newer framework, if he's the reason for it, I guess it would be called Schrem's 3. But I think he's hoping that somebody else will step up to the plate. But I think at this point, everyone thinks that, hey, you're the transporter flow of data guy, so you can file the lawsuit.
Yeah. I think I remember watching the same podcast that you did with him, going, I didn't even realize my name would be on this, and I'd be the guy to represent so many people who felt the same way, but I just fell into it, and here I am. But you mentioned, and I'm sorry for digressing away from this, but kind of connecting it to GDPR is the kind of very relevant regulation that we haven't talked a lot about yet, and that's because it's a whole world. It's also a bit different from some of the frameworks and positions we've been talking about so far, because we're talking about usually government to government entities or flows of information between countries, regardless of whether it's a business or a big corporation, or an agency or an organization that's more affiliated with the country formally. Now, GDPR is comprehensive in the sense that it's enforced by any organization that does collect, process, or share information that's personal in nature. And I will say that it is considered a data protection regulation that follows what I was talking about earlier, which was the data protection. I'm even doing it. Data protection directive of 1995, and part of the GDPR was to again focus on the fact that because the data protection directive was a directive in the EU, meaning all of the member states can implement it, accordingly, and not bound by one centralized rule or law. The GDPR said, hey, this is a regulation, so the way it's written and the minute we enforce it, it is enforceable. You don't have to extrapolate or interpolate, I think is the proper term, to conform to your own member states' kind of existing frameworks. It's
Sure.
it is how it's written, and you might have data protection authorities within each member state, but the principles behind it and the lawful basis for processing for organizations are the same, so long as you have some presence in a country within the European Union. I believe this was the first time too within GDPR that the requirement for a data protection officer was a requirement. So for certain organizations of enough size, and if there is a high risk associated with high risk to individuals related to the information that organizations are processing. I didn't see that in a lot of the other frameworks, or even that earlier data protection directive. I didn't see that obligation to appoint a data protection officer, which I think is interesting because I see them everywhere now. But essentially GDPR takes in the principles it emphasizes is not far off from what we've talked about this entire episode. Those guidelines, most of those, if not all of them, are reflected as well into GDPR. So it seems like the GDPR was another, hammer on a nail that wasn't quite in the ground yet with what was earlier directives and frameworks intentions to do with organizing an entire continent under data protection principles without being so restrictive that you can't modify it to your own needs or to the needs with other organizations that also process data. But I'll leave it there since I can kind of ramble on forever. It's a lot. GDPR is.
It is a lot, and I think when we first started talking about this episode, we were thinking we were going to include GDPR in it, but GDPR it's really a monumental thing. There's a lot to it. I actually keep a printed text of
Nice.
right here on my desk. I don't know, saying how much of a privacy nerd I am. But it's worth getting into. I think we should talk about it in a separate episode and get into more of like the provisions and the essence of it. And there's a lot to be said for what's happened as a result of it. The potential for fines is pretty significant, and I was surprised by that when I first heard about GDPR. But they've used it. Like there's some massive fines have been levied against some large companies. We'll have to see how much we're going to talk about those, but I think we'll come back for a different episode and talk about the specifics of GDPR. So stay tuned for that.
Right. But again, to wrap up the episode, thank you so much for listening in, everyone, and I hope you learned some pretty niche stuff. I know until I had, our outline written out, I didn't imagine that I would, consume the information I did, especially from the time periods we looked at, right? We didn't get to, modern computer and right. Information processing type history until very late in the episode. But that just goes to show how not, I guess, novel in a lot of ways these ideas that are pushed in the name of privacy are. We're not basically just taking them out of thin air and going, hey, this is what I want, do it. Like it was said before we knew the means that things like individual privacy could be exploited without really knowing from a consumer perspective. It was what very large governments agreed upon for a long time.
Yeah. Well, thanks for engaging in the conversation. I enjoy the chat, Rachel, and the being prompted into having to do some research to get ready for our chats. And like you said, appreciate anyone who's sat through and listened to this. We appreciate it.
Goodbye.
Bye.